Warning, we are not your attorneys. Please, don't take anything we say as legal advice. I'm Geoff.
I'm Mike.
And I'm Derrick.
And you are listening to the Not So Grand Jury,
which is still sponsored by Morwa PLLC. Hey everybody, Editor Derrick here. As the name of this episode suggests, this is part 2 of a 2-part episode. So if you are starting with this episode and haven't listened to part 1, we highly recommend you listen to part 1 so you can listen to our commentary regarding other aspects of season 2 of Daredevil that don't involve the Punisher trial. This episode is going to focus mostly on the Punisher trial, and we are going to be jumping right into a conversation on voir dire. How long, Geoff, do you think voir dire happens in the show?
Okay, how long does it happen in the show?
Because the judge seems really unhappy, but it seems like it's just a long day.
Yeah, I was going to say a matter of a couple days at the most.
By the way, that's how long most of voir dire takes in a murder trial. Is it takes a couple of days to make it perfect.
Sure. And I mean, so the voir dire process, I mean, you could have in a case like this. Let me back up. We're talking here about a case with like 30 murder charges, something in that realm. When I was an intern at the U.S. Attorney's Office in law school, we had a case with like 19 defendants in this massive RICO thing. And we had literally like thousands of potential jurors to go through. And I remember just box after box after box of all the jury questionnaires. It was insane. And that took a while because you just have to churn through so many people and there's only so much time in the day. So I could see in a case like this where you're having to check, okay, did you know any of the victims? Did you know any of the, officers involved in the investigations on top of all of the other normal questions? It could take a while. It doesn't in the show.
No, in the show it takes maybe a couple days, and honestly, I think they sort of imply it takes a very hard day.
Right. Because throughout this, we're also seeing Matt, fight the hand and all this stuff.
Right.
So, yeah.
They don't imply he fights anyone during the course of voir dire.
Right.
Which implies to me it's one day. Maybe two. Yeah.
Isn't Electra like recovering from an injury at the same time? And
Right. Exactly. Well, and also, if this is a New York Supreme Court judge, which it would be if it was a criminal trial in Manhattan, they can only work between like 9:30 and like 5. And then the courtroom shuts down at 5.
Oh, okay.
So maybe the judge had to do a full day and she was very mad, which tracks for some of the New York Supreme Court judges I've been
And for listeners unaware, New York has a weird court system where the lowest level courts are the Supreme Courts. And then the actual, what we would consider the Supreme Court of New York is the New York Appellate Court?
New York Court of Appeals.
New York Court of Appeals, okay.
So it's so it's the Supreme Court is the trial court. The appellate divisions are the second level, and also known as the first, second, third, and fourth department. And then the Court of Appeals is the highest court in New York. So, that's only slightly confusing to everybody. And so, a good example of how long voir dire could take in the Boston Marathon bombing, which I'm equating to not being terribly far off because of how, even though the Boston Marathon bomber, I think he only ended up killing 3 people, but that's not here or there. It was the act of what they did and how they did it. There was 100-question screening form and 3 weeks of in-person questioning to get their jury.
Yeah.
And even then, the First Circuit actually overturned part of the decision, which then the U.S. Supreme Court then re-overturned in U.S. versus Zarnov in 2022, where in a 6-3 decision, they said it was fine. I kind of forgot it had gone up to the Supreme Court, to be honest. But they overturned the first circuit and said everything's fine. They're entitled to go for the death penalty. And he's been sitting on death row since. So he's been on there for the last few years. But again, in that case, 3 weeks of in-person questioning, and I was actually shocked it wasn't longer, to be honest.
And that's just to pick the jury. We haven't even started the trial yet. That's just how long it takes to find 12 people and alternates.
In the time it took from the Punisher to get arrested to verdict, probably is the amount of time in the Boston Marathon case they just picked the jury.
I mean, yeah, with time, time to spare.
With time to spare, right? Yeah, that's exactly. So that, in real life, that case would have taken a very long time to do the voir dire. Another thing, and I don't think they mention it in the case in the show, presumably the jury would have been sequestered for most, if not the entire trial.
I would imagine.
To stay away from public opinion, everything else. And again, the examples I have are the Derrick Chauvin murder case, Bill Cosby's sexual assault case, George Zimmerman, O.J. Simpson, and every single one of them, there was a version of sequestering, the O.J. Simpson case being the most insane part, where the jury was sequestered for 265 days, costing the taxpayers approximately $3 million so that jury could be sequestered. I'm not saying that would happen here. I am saying that this trial, which we're about to get into, would not have lasted what I believe to be only a few days.
There's a million things that would have prevented that, yes.
Hi everyone, Derrick here with a brief message. The Not So Grand Jury is sponsored by my law firm, Morwa PLLC. One of Morwa PLLC's many practice areas is business law. If you are a business owner or someone who is thinking of starting up a new or side business, you need a legal team who can efficiently provide you legal counsel, keeping you and your business away from potential legal issues, and if necessary, representing you in any disputes that do arise. We pride ourselves on being cost efficient while also getting to know our clients. If you want less stress and more support, you need Morwa. If you would like to set up a free consult, please click on the link in the show notes. Visit our website, www.mooreatty.com. That's mooreatty.com. Or email us at contact@mooreatty.com. And now, back to the show.
I guess we're ready to move on to the actual trial itself.
I think so.
Sure.
Yeah. Geoff, do you want to do the opening statement?
Yeah, I'll play the DA's opening statement first, and then we have Foggy's opening statement. But we'll pause in between and discuss. Here's the DA.
Be seated.
Looks like you're a man down.
Ladies and gentlemen of the jury, the defendant has been indicted for several serious crimes, but I'm instructing you as a point of law that an indictment
Those college stress streams? When you
As
show
he
up to
sits
a
here
class in your
today,
underwear?
the defendant is presumed
That's me right now.
innocent until proven guilty.
God damn. Matt was supposed to deliver opening, not me.
Miss Reyes, are the people ready to begin opening statements?
More than ready, Your Honor.
Should we be worried? I mean, there's no way Matt misses this, right?
Ladies and gentlemen of the jury, Frank Castle brutally tortured and murdered 30 people. 30 that we know of. He took the law into his own hands, acted as judge, jury, and most violent executioner. You will hear that the defendant's victims were criminals. But the victims are not on trial here today. And justice does not belong in the hands of a man like Frank Castle. This isn't the Wild West. Justice is served here, in a court of law. And it is up to each of you to take back the city from lawless vigilantes like Frank Castle. This man is no hero. He's a serial killer. And he is guilty.
Okay, first on the procedural side, this is such a minor thing, but it annoys me. In New York, they're justices, not judges.
Oh,
So they never would have said judge. They would have said justice, which goes along with the whole Supreme Court concept.
I didn't actually know that. I don't practice in New York. Okay.
Fun fact. So if the introduction would have been justice, not judge.
Right.
Small thing, but I heard it and I kind of laughed. This is all procedural stuff before we get into the actual shitty opening statement. They don't say it, but they imply that this is like the first time the jury is brought into the courtroom and that like this is where we're starting the case.
Sure.
If that were true, the judge would have, give or take 15 to 20 minutes, if not longer, of pre-trial. This is what I'm telling the jury before we've even started.
Yeah.
The lawyers would have agreed and worked together, theoretically, on jury instructions, including instructions that would go through various parts of the trial. There would be instructions that would happen before they ever gave opening statements. There would be instructions after opening statements. There would be instructions before they deliberate, and then there'd be instructions after they deliberate. And typically the lawyers come together and sort of agree on these things. And I believe in both criminal and civil trials, there are what they call pattern jury instructions. So there's like standard jury instructions that, are typically used in New York. And some of them are applicable, some of them may not be applicable. If you don't have experts, you kick those out. If you have, eyewitness testimony, you would add those things like that. There is no scenario where the pre-opening statement instructions would last less than 10 minutes, let alone 15 seconds. And again, you see this all the time in TV shows and movies. You never hear that part. You always just go in and be like, they usually pick like one or two of them. So like with this, I didn't really hear it over what Foggy was saying, but basically it was like, indictment doesn't mean guilty. Keep your mind open. Frickin' move on. Like basically that's what it was. There would be a whole thing about what does an opening statement mean, that this isn't technically evidence. This is a statement. A statement means that the sides are giving you information on what their case is going to be. You cannot actually take the statement as anything more than that. And there would be a whole nother laundry list of things they would do. So procedurally, that's not correct. Is there anything else procedurally you guys noticed that was just...
Procedurally?
She walks through the well too,
Yeah.
right?
Yeah.
You wouldn't do that.
You'd stand at a podium.
So yeah, if you walk through the well, you're going to get tackled.
Correct.
In a criminal trial, you're going to get
So I know we've talked about this a couple of times, but for those of you who either didn't listen to previous episodes or weren't paying attention for our trial scene commentary, the well is the part of the courtroom that's sort of in front of the counsel table, closer to the judge, closer to the witness. That's referred to as the well. And you see, it was like a lot of older TV shows, at least I noticed, where the lawyer would basically ask for permission to move about the well. That is not something that happens typically. Like you typically and at least in my experience, they don't allow that. They do allow you to you ask permission to approach, you ask permission to go to the witness. You typically can't stand in the well.
Okay. Yeah. I was going to say, I regularly ask to approach to hand up some document or something.
Yeah.
But that's
right. But and I can't remember what show it is. And if I remember it, we'll drop it in. There was one of the legal shows, and it may either be Law and Order or it may be something else, where they regularly ask to move about the well freely, and the judges just grant it as a matter of course. And you're like, no, that wouldn't happen. Most courtrooms, actually, not only do they not let you go to the well, you stand behind a podium, and that's where you give every single thing throughout the entire trial. If anyone watched the Johnny Depp, Amanda Heard trial, any of the other ones, they go to one podium, and every time a lawyer spoke, if it wasn't an objection, it came from that podium. That's the only time you're allowed to talk. That is likely what would have happened both for her testimony as well as Foggy's. So
and
I had that little issue.
By the way, these days when we have, modern technology and plenty of courts are, streaming their proceedings, they haven't mic'd the entire well of the courtroom. They've mic'd the podium, and that's where you stand so that everyone can hear you.
Right.
Yeah.
There are 5 microphones in the entire courtroom. The podium, the 2 counsel table, the witness, and the judge. That's it. There's no other mics.
And I mean, we have to, it would make very boring television. It does make very boring television. For a dramatic TV show, you need to have some movement of some sort. So, of course, we see it happen all the time. It's going to happen a bunch during our conversation tonight. But yeah. And then there's her opening statement, which is both
horrible,
bad and I think objectionable.
I think the whole thing's objectionable.
Because
But can we talk about the purpose of an opening statement?
Yes. Yeah. An opening statement is you are giving a preview of the evidence that the jury is going to see. That is the whole point. You're giving, if you're the prosecutor in a criminal case, these are the charges. This is what we're going to show. This is what we're going to prove. And at the end, you'll be able to say beyond a shadow of a doubt that he was, guilty. And then if you're the defense witness, if you're a defense counsel, you're going to get up and do the opposite. What are they going to fail to prove? And we see actually a little bit of, I think if I remember right, Lincoln Lawyer did for a TV show a reasonably decent opening statements because they did that. It took 20 seconds, but they still did what you do in an opening statement. She does not do that here. She's talking about, she's going off about vigilantes and he's a serial killer and all this stuff. That's like, no, that's not what any of this is.
I also just want, because I happen to have in front of me the proposed jury instruction I did for the trial I was supposed to do a couple months ago and then ended up not doing it. So I can tell you what the New York pattern jury instruction is for openings. And I will very quickly read it. This is the judge talking to the jury.
Justice.
And by the way, well done, Jeffrey. I don't know if I don't know. I don't know if you have a thing that you can, like, any of your various sounds that you could play, but if you have a celebratory one, you are allowed to play it.
Maximum Derrick.
I'm really not what you would call a winner.
That was the best I could do.
So that means I'm not a winner. Got it. Okay, moving on. So here's so in a trial, as I mentioned, that the judge would be giving these instructions to the jury. After some very brief instructions, which is a introduction of the jury and an explanation of who the parties are, the judge would then say, at least in the instructions that we have proposed, when I've completed these instructions, the attorneys will make opening statements in which each will outline for you what it expects to prove. The purpose of opening statements is to tell you about each party's contentions so that you have a better understanding of the evidence as introduced. What is said in opening statements is not evidence. The evidence upon which you will base your decisions will come from the testimony of witnesses here in court or in sworn testimony given before trial or in the form of photographs, documents, or other exhibits admitted into evidence. And then we go, counsel for plaintiff will make an opening statement first, and then is followed by counsel for defendant. After the opening statements, then the plaintiff will introduce evidence in support of its claims. So that's generally what the judge would say, which is an opening is not evidence. In fact, an opening, as the jury instruction says, is designed to give you a better understanding of what evidence is going to be introduced. So, and I agree with you, Lincoln Lawyer actually did a pretty decent job when it came to openings and closings. Like you said, they were shorter than they typically would be, but they did a decent job being like, here's what's going to happen. Nothing here from the prosecutor. Just a lot of objectionable, he's a serial killer shit, which is not helpful. Like,
no.
And by the way, she's got a phenomenal case.
The jury has has no idea who they're going to see talk to them. They have no idea what each witness is going to be talking about. They have, no idea what needs to be proved for each of the different, are they all first-degree murder charges? Are there, other charges? They have no idea. And it's just, it's ridiculous. It's pretty standard for, legal dramas, but it's bad.
Right. Well, and especially, not only is it bad, but like, prosecutor typically is the person who's going to be straightforward, right? They're going to be the ones who, like, especially in a case where you have a defendant dead to rights, you are going to sit there and list off all the shit they're about to hear. You are going to hear how the defendant methodically and systematically murdered X number of people using military-style weapons in execution style. You will hear from the medical examiner who's going to say this. You will hear from the police officers that say this. You will hear from the detectives that say this. Like, you methodically go through every single bit of evidence to show that you have the motive, the means, the opportunity, all that stuff that we've talked about previously. And you, in fact, stay away from the flowery language of serial killer generic statements on like what a monster he is. Because actually, that is appealable error. Like, that was the first thing I thought when she ended her opening statement was, appeal, already got it.
Yeah.
This also falls into they may have committed a little bit of malpractice here. There's a bunch of objections that should have been made. They should have filed for her to recuse them. There's a couple. They didn't know all the facts at that time, but there was enough there that they had a very good argument to get this case either shut down or at least get a different attorney to run on the other side.
Well, and also, let's assume that the judge is even decent at her job. I could see a judge cutting off the prosecutor to be like, okay. Because I will say, as an attorney, and I've done a few trials, you really don't want to object during statements.
Sure.
Like, you want to not object to openings. You want to not object to closings. It doesn't look great in front of the jury. You do it once to make a point that, like, Your Honor, are we going to talk about the evidence, or are we just going to sit here and spit accusations? You know,
Right.
like, you make one statement and you move on. I could see the judge unilaterally being like, counsel, like, what are we doing here? And again, a good justice would do that.
Yeah. There were a few
Now,
times during this, and we'll get
yeah.
to them, where I thought, why even the judge at this point should be like stepping in, because my
Right.
gosh.
Well, I mean, because let's be honest, like, a lot of times, and this is true of any federal trial, civil trial, state trial, whatever it is, the last thing the judge wants is to have appealable error, where like you have allowed something in or you have not allowed something in that could cause the case to go up on appeal, get overturned, and have to do a whole new, brand new trial, which happens more often than we all care to admit happens, which is, by the way, the worst as a client when you have battled through however long of getting through a case, getting to trial, winning or losing, and then having to go through possibly months, if not a year plus of appeal, only to be back in the same exact situation you were in however many years ago.
And it's hell for your clients, but the judge also doesn't like it either. The judge wants to get this case done and move on to the next one. They don't want these things lingering on their dockets for ages.
Yeah. Right. Exactly. So, yeah, in real life, that's not a statement that doesn't get all the way through.
Yeah. I mean, it was so short, they might not have had time to realize that that's what she was doing, but
I actually was waiting for the judge to be like, wait, that's it? Yeah. Oh, okay. I guess defense counsel can go now.
And that is what Foggy does.
Mr. Nelson, are you prepared to make your opening statement?
She's good.
So are you.
Mr. Nelson? Mr. Nelson, are you reserving the right to make your statement at a later time?
Screw it. No, Your Honor. The defense is ready to proceed. Ladies and gentlemen of the jury, the defendant, Frank Castle, is not... Sorry. Mr. Castle is as much a victim... No, he's not. Okay, so you're 19, standing in hot sand, sun burning down, noise, yelling, gunfire. The only thing that you know for sure is that you're surrounded by an enemy that wants you dead. But you do it. You endure it. Why? Because you have orders. And you have a duty. And also because your life doesn't end here. You have people you love waiting at home. Because aside from being a decorated Marine, the man before you is a good husband and an excellent father. Frank Castle returned from the hell of war, wanting nothing more than to pick up his life. But his wife, young son, and daughter were brutally murdered by criminals. And no one, not the police, and certainly not the district attorney, stepped up to make it right. See, Frank Castle never came home. He just traded in one war zone for another. This trial isn't about vigilantes. It's about the failure of the justice system and how one man, Frank Castle, is being used as a pawn to cover up that system's mistakes. The prosecution wants blood. But as the judge just said, to get it, they have to prove their case beyond a reasonable doubt. So all I'm asking of you today, keep an open mind. That's all, Your Honor.
Okay. Again, pretty quick. Derrick is reading from a screen. Derrick, I saw you jump and start searching for something. I imagine you're about to talk about whether or not you can defer your opening statement as a defense attorney.
I'm pretty sure you can in New York.
I had a feeling that you could defer it until the start of your case in chief.
Right. I think that's relatively normal, right? Because I mean, I say it's normal. I only practice in a couple of jurisdictions, but he had it right there. If you're effed, to delay it.
Yeah. I mean,
and by the way, there's a lot of reasons to delay your opening statement. You know, hold back your information until you see everything the prosecutor has to offer,
Sure.
and then make an opening statement that is very specific to what you want to offer. And by the way, in this case, wouldn't be terrible because your client's kind of dead to rights on the actual liability part. Let them get everything in, and then you focus on everything
and
else.
you've had no time. Now,
Right.
At the same time, there is the downside of the prosecutor is the only one telling the story for much of the trial. And
Correct.
so you do want to have an opportunity to get whatever framing you can in at the start. But that can easily be outweighed by
the fact that your fellow counsel, well, it's also outweighed by the fact when your fellow counsel who's supposed to give the opening doesn't show up.
Right.
That's probably a good reason to be like, yes, Your Honor, we will wait until our case in chief to present our opening statement. Now, in this case, their case in chief is going to start tomorrow, but right, because obviously the prosecution can do their whole case in chief in a day because that's ever happened once. I mean, listen, if this were a real case, New York's case in chief lasts 2 to 3 weeks minimum.
Yeah, you have 30 victims.
Right. Like minimum 2 to 3 weeks. And that's an understatement. Okay. Let's put ourselves in this situation. All three of us have been fired by our firms. Apparently, my firm has collapsed. And then we have all been hired by a criminal defense firm in New York. And we are supposed to be working alongside hey, we're the two people on this criminal case.
Okay.
And another doesn't show up and is supposed to do the opening statement. I don't know about you guys. I would find a way to ask for anything to adjourn this shit.
Oh, absolutely, yeah.
I would vomit on the table. I would accidentally stab my ear and start bleeding. I don't know what I would do.
If your client's going to be sentenced to life in prison, then there's no benefit to getting this over with sooner.
I would, Your Honor, there is something really wrong. My co-counsel is nowhere to be found. Like, I would have done this before we ever got the jury out, right? I would have gone up to the clerk and been like, I'm so sorry. Like, I can't find my co-counsel. Something is very wrong.
Sure.
Like, can you give us, tell the judge, can we start a little later today while I try to fucking find my co-counsel? And I'm sure at some point the judge is going to call us into our chambers and I'm going to be like, I can't find Geoff. Like, you got to give me an adjournment so I can find my co-counsel.
Sure. And by the way, if the judge, offers you the opportunity to hold off.
Yeah, you do that.
Yeah.
I mean, so that's step one. So step one, I'm not making the opening. Step two, let's say that the judge says, no, I don't like you. You're going to give the opening. Congratulations. Which would honestly don't think would ever happen. I'm not saying the judge would be happy, but the judge kind of has to give you the opportunity, right? So let's say it doesn't happen. The judge gave you the out. Do you want to defer your opening to the start of your case in chief? And again, that's rare, but in this case where you're really focused on like mitigation and reason, like let the prosecution do their thing, because you're going to come in and be like, that's all well and good. We have never said that he didn't do it. So honestly, the last 2 weeks, you learned a lot of information that we didn't have to be here for because we could have agreed to that. However, what you didn't hear, and then you list off all the mitigating things, right?
Sure.
Like that's sort of what you would do. I'm not saying it's great. In fairness, I'm not really sure what their argument is in this trial.
So
I'm not sure if the opening statement helped us to determine what their argument is.
I think, yeah. Well, do you want to get into what I think their theory is here? Because
I'd love to hear what you think their theory is.
They don't lay it out well. So there's some back and forth of, do we want to do a, PTSD? He, did not have, he didn't have the capacity to commit a crime. Frank shoots that down, but they do come back with, he had this brain injury. He was shot in the head, and the trauma from that and the emotional distress of, witnessing his family being killed essentially make it so that he cannot premeditate these actions, that when he goes into, he goes into a fugue state, and none of this can have been planned because that's not how his brain works. So in first degree murder, generally it has an element is that it is premeditated. So if you undermine that, then it falls to, I'm not sure of how New York structures their murder statute, but it falls to either second or third degree murder in that situation generally. And in this situation where it's like, no, he did everything. No one's disputing that. That can be your best outcome as a defense attorney. And I think that based on the expert witness that we have a little later, I think that's where they were going.
So I believe Geoff in New York, and this is doing very quick searching. First degree is sort of premeditated with planning, deliberation, whatever. Second degree is with malice aforethought, so it has to have intent.
Okay.
And then the third is when you start getting into manslaughter and sort of the lesser included offenses. So like they probably are arguing definitely not premeditation. They may even be arguing didn't have the intent, but
yeah,
probably
all I know is they directly attack premeditation
right.
in the question.
I thought they were going. I agree that was part of their argument. I think they also may have been trying to push a jury nullification thing.
Oh, maybe. Yeah.
It's never really stated, but it was also kind of trendy at the time to talk about. So
sure. Anyway, that's my theory of where they were headed, which isn't a bad way. Like, like I said, getting 30 first-degree murder charges down to second-degree murder charges is potentially a big win for a defense attorney in their position.
Sure.
And your client, who
again,
he admits did the act, it's probably it's not a good outcome for him, but it's the best outcome he can possibly expect, I think.
This again goes back to the whole talk to your client to know what your client wants. Now, obviously, we find out later the whole he wanted to be in prison, although that's confusing to me.
That's confusing too. Yeah. It's not.
Well, they needed he wanted to be in prison for the plot,
right,
guys.
Yeah.
So that way he could fight. That's how he meets the Kingpin. How is the Punisher going to meet the Kingpin otherwise?
He needed to be in prison to kill the guy, then to get out of prison.
Yeah, for the plot.
Right, because someone in the prison maybe knows something about how his family was killed, who was behind it. But he doesn't learn that until he talks to Kingpin in the prison. So what was the guard? So a prison, a bailiff or something in the courtroom says something to Frank. We never hear it, but it causes Frank to have this outburst. Yeah, it's not clear to me why suddenly he's trying to end the trial that he pled not guilty to. Like, his motivations are all over the place.
Just doesn't make sense. Now listen, I am not going to say that Foggy did a good opening, because he didn't. I'm also not going to say he did worse than the prosecutor.
No, at least he said, keep an open mind, and they have to prove beyond a reasonable doubt.
Right. He said a couple things that you are basically required to say as a defense counsel before you start a case, which is, and again, the heavy focus on the burden is on the other side. A heavy burden is on the other side. And
what's interesting in this situation is Foggy's been the one doing all the work. He is actually in the best position to to make an opening statement, because Matt has, again, been AWOL fighting the hand. We've in the episode, we see Foggy going over all the evidence, photos from the crime scenes and things like this. So I think he's best positioned to give an opening statement. He just didn't have any time to really prep.
Now, interesting question. Do we think Matt had an opening statement ready?
No.
Okay.
Because he was off Daredevil.
That's what I thought.
Matt is
right.
So we'll get more into this when we do the actual review at the end, but I have no memory of season 2 of this show. I know I watched this. I remember sitting in my living room watching this when it was released on Netflix. I have no memory of any of the details of the plot. And I don't know if it's because Matt's just a giant asshole through the entire season and I just didn't care. I don't know. But
I have a distinct, we've said this before, actually. I have a distinct memory of the season because you and I were ranting to each other about the closing argument / cross-examination.
Yes.
Not even cross-examination,
just
questions of
Matt's questioning. Should we get into that?
Yeah. Sure.
Jump around.
But that was somewhat of the idea behind this podcast originally, was we were ranting about this and everything that it got wrong.
So yeah, let's listen to when Matt finally shows up and does something legal.
Do something, Daredevil. Lazy bum.
Matt decides to lawyer as a lawyer.
Please state your name for the record.
Frank Castle.
Mr. Castle, you've been charged with multiple capital crimes. Been called a killer incapable of empathy or remorse.
Yeah. So I hear.
Frank, may I call you Frank?
Yeah.
Frank, we've heard a lot about neurochemistry and psychology and all things unfolding scientifically and otherwise inside your brain. But I just have one question I want to ask. What happened that day? The day your family was so tragically killed? It's okay, Frank. I understand it's difficult.
Do you? Do you understand? Because I don't think you understand shit.
Like permission to treat the witnesses hostile, Your Honor?
Granted.
All right, Frank. You don't want to tell us? I'll tell you. I'm going to tell you exactly what kind of man you are. You're the kind of man this city needs. Because, ladies and gentlemen of the jury, we all know this city needs help. Needs it now. Not tomorrow, not next week, not when the day comes when the corruption that Wilson Fisk left in his wake is flushed out for good and the police force is finally back on its feet. We need it now. Because this city's been sick. And the cops, they can't fix it alone. We all need men and women who are willing to take the fight themselves, the kind of people who risk their lives so that we can walk safe at night in our own neighborhoods. The ones our esteemed district attorney here is trying so hard to destroy. New York needs these people. We need heroes.
Order.
The help they offer. And the hope that they provide. Frank Castle wanted to help, but he took it too far. He shot people. He killed people. It's against the law. And he broke that law many, many times. Now, I don't like him any more than you do, but here's the thing. He's not a common criminal. He's not malicious in intent. Frank Castle is actually a good man. He doesn't know the difference between right and wrong anymore, and he doesn't need punishment for that. He needs help. Our help.
Okay. So,
Hey, Geoff, what does it mean when you want to treat a witness as hostile? Does that mean you just get to give a
that's
speech?
an excellent question, Mike. So, okay, a little bit of just basic trial advocacy. When you are an attorney and you're questioning your own witness, you ask open-ended questions. You don't ask yes or no questions. When you start asking yes or no questions, that's called leading the witness. And you cannot, and when you are questioning the other side's witnesses is when you can start getting into essentially where the question essentially contains the answer. I'm in this moment having a hard time really articulating it, but it is...
You saw the defendant leave at 9 p.m., didn't you?
All those didn't you questions, that is, you are questioning a hostile witness there. You are questioning the other side's witness. You can be more forceful in your questioning, be more accusatory. Here, so what Matt does is he asks Frank a question and then asks the judge if he can treat Frank as hostile for no apparent reason. Frank is his client. There's like there can be circumstances where you would treat your own witness as a hostile witness, but it requires a fair amount of justification before a judge is going to let you do that. Because again, judges don't like to get their stuff thrown back at them after an appeal. Here, he asks to treat Frank as hostile and then doesn't ask another question. He just starts giving a speech and wandering around the well the entire time. You'd think the guy pretended to be blind, well, who is blind but not really, would not move around quite so much.
I was about to say, it's a blind guy moving around the well. Like, you'd think someone would stop him. It's okay, guys. We've seen some bad trial scenes through our couple years of the not so grand jury. This might be the worst one.
It's bad. The whole, I mean, and Matt's is sort of the pinnacle of the badness, but there's nothing good in this trial scene.
Like, there's a couple scenes in the trial that are interesting conversations to have. The one with his commander, who turns out to be a much bigger witness or much bigger deal than I thought. And by the way, when they called him, I wasn't like, oh, he's going to go away and never come back. Like, I was like, oh, he's going to be a part of this at some
Clancy
point.
Brown.
It's just a question
you don't
of
bring
what
him
level.
In for, yeah.
No, Clancy Brown doesn't come in for one direct and across. Like, that's not how that works. I actually was going to have an interesting conversation with you guys about, like, would you have been willing to not on direct say he's the one that's talking about himself? Because it's actually a very interesting ploy to make the prosecution fall into that trap.
Yeah.
And by the way, this happens all the time in TV show and movie trial scenes where, like, you weave a little bit back and let the other side fall into the trap. It happened in Lincoln Lawyer. It happens in a few other things. But this was an interesting trap because the direct got the point across.
We're talking about Clancy Brown now?
Yeah, we're talking about a little bit.
Yeah. So, sorry, I had moved on because the other one's so freaking bad. I didn't.
It's amazing. This is a mistake on the prosecution side that it's believable but almost on the very edge of it, where, like, you had no idea, you didn't do any research that their witness had been there in person with them.
Their witness who only has one arm and is talking about a superior officer who's missing an arm.
One arm man is here again.
I missed that. That's fun. Yeah. And I believe, doesn't Reyes, she whispers to her, like, assistant, everything's redacted, so she didn't know.
So she had no idea.
Right, but listen,
but you still have a list of the witnesses ahead of time.
We are learned long before law school. When we are doing mock trial back in high school, you are taught, do not ask a question to which you don't know the answer.
There's no depositions for this because it's criminal trial and this is just a random witness that's going to be there.
Well, again, they didn't have time for depositions. The trial happened the day after he got.
He's just a character witness for Frank. That's all.
Right.
Yeah.
Right. And so, one, it's badly done by the prosecution, but again, I don't think Reyes has covered herself in glory to this point, so I wouldn't think that she's not a great U.S. New York DA, that's for sure. She may be politically powerful. She's not smart when it comes to the law. But I thought that was an interesting thing. Like, do you hold something back and make her look stupid? And it worked out perfectly. Like, that's a fun conversation, right? Like, that's a conversation to be like, hey, like, I could see a scenario where you do that in a real life trial. Like, Lord knows I've had thoughts where, like, do we get 95% of the way there? And if they're dumb enough to ask the 5%, it makes them look stupid. But that at least was a semi-normal direct with a cross. Everything else was just horrible.
So were I in that situation, I don't think you can avoid at least discussing that a little bit, because what we don't see in many of these scenes is you laying the foundation for the questions that you're asking. They just call this guy who's like, an officer, and they start asking questions about Frank. That's not how this works in a real trial. You call him to the stand. Okay, what's your, name, rank, whatever. Do you know the defendant?
Right.
How do you know the defendant? And you go through basically explaining who this guy is in relation to your client or the case or what have you. And so I don't know that you could possibly without
they would have objected to hearsay too, because he's probably testifying.
Yeah, because if it's just I read this report back from my command center or what have you. You have to explain how he knows what he's going to talk about.
Right.
Yeah. So I don't know how you get to the point where you're asking these questions without that information being clear.
Yeah, fair enough. Fair enough.
Whether or not he has.
I mean, I guess the only. Yeah, because
it's just another one-armed man.
Because he has to show he has personal knowledge of it.
Yeah.
Yeah. Interesting. But again, the prosecution's stupid, but that's besides the point.
I mean, unrealistically stupid is the problem.
Right. Yeah, true. No, by the way, the Punisher direct might be, that may go down as the stupidest in a vacuum trial scene. Ever. Because it's just dumb. If I was a judge, I think I would throw shit at and be like, "What are you doing in my courtroom right now?"
But he's blind.
It's sort of
you got to give him. I don't know. The judge wants to cut him some slack or something.
Yeah, it's not good. There's no good lawyering in the show, and I do like the show is a problem.
And
by the way, because I can turn my brain off. I can turn my brain off when it comes to that shit. I like Suits, and Suits is ridiculous when it comes to the lawyering. Sure. But when you look at this from a legal perspective, even I had a hard time turning my brain off for this trial, because it's so bad.
And
I remember how to Get Away with Murder's bad. I don't think it's close to this bad.
This is certainly up there as some of the worst. It's just bad. There's the times where something is really dumb but plausibly could happen. So a district attorney being there with the police on an operation is a thing that I could imagine bordering on Reno 911, but also could happen in real life.
Yeah.
And then there's none of this works like this. They're going to be waiting for you to say something because you just made a bunch of noises with your mouth, but you haven't actually asked him a question.
Yeah. I had
this. This is the quintessential Lincoln lawyer. Are we going to get a question, Your Honor?
I should pull that clip.
And at least that would have been something. But and I guess honestly, from the prosecution side, they're yeah, fucking keep talking. This is just stupid.
Sure. The first of all, you're putting the Punisher on the stand.
Yeah.
Well, you guys talk however you want to talk.
And
but the judge would have stopped this real quick.
And the whole reason,
and certainly wouldn't have let you make your own witness hostile by simply not answering one question.
Yeah, he answered the question. He just didn't really like the answer he got. It's so dumb. But the whole reason Matt is even questioning him is because Matt feels bad for being, absent for the rest of the trial, which he's done no witness prep. He and Frank have spent more time together as their alter egos than they have doing any sort of witness prep or, just talking as human beings do. The whole thing just blew my mind.
Frank doesn't really have an alter ego in this.
I guess, yeah.
There's this funny,
Frank.
This is the Marvel Cinematic Universe thing. Ever since Iron Man had the thing where very few of them actually had alter egos, except for Iron Man, or except for Daredevil and Spider-Man.
Yeah,
you just know everybody's name otherwise.
I pulled some more clips of various people. We have some expert testimony that he is a terrible expert witness. We have the Emmy. We could maybe talk about the Emmy and the witness tampering that Elektra engages in. But the trial basically ends with that testimony because then Frank goes completely off the rails because now he wants to be thrown into prison
for the plot.
I love how the Emmy just decides I have to make a statement.
There, hang on.
Do you have the clip? Because that's also a fun one too. That would totally happen in real life.
And so, Dr. Tepper, the medical examiner's office can confirm that the 15 victims found at the Irish Social Club all died of multiple gunshot wounds.
Yes, that's correct. All 15 victims died of wounds inflicted by the same caliber bullet, each shot multiple times.
Thank you. Your witness.
Cross your fingers.
I'm crossing everything.
Dr. Gregory Tepper. How long have you been medical examiner for the city of New York?
14 years, give or take.
And how many death certificates would you estimate you've signed in that time?
Huh? I don't...
That's probably in the tens of thousands.
Objection, Your Honor. Leading the witness. I'm not sure where.
Mr. Murdoch.
I have something I need to say.
Doctor?
Your Honor, I'm sorry, but I have to. On the record, I need to say something about what I did.
Clear the gallery.
There are so many things wrong in like a 2-minute time frame.
True of every scene we've talked about so far.
Right. Well, one, there's no way that that's how they end the Emmy's testimony.
Sure.
Also, they're clearing the chamber because the witness is answering a question.
The witness wants to give a statement on the record.
Right. I want to make a unilateral on the record statement.
Get out of here.
And then and the first response from the judge is clear the gallery.
Which is not the jury. She did not say that the jury should leave, but the bailiff goes ahead and gets the jury out of the room anyway.
Well, because the bailiff's confused too.
To be fair, you probably should be.
Several people are having some sort of breakdown. Let's get everyone
like the bailiff's like, who do I get rid of? Like, what's happening? Like, how does this work?
No, so let's start with okay. You've got the medical examiner being examined by the prosecutor. That testimony does not end with yes, all of these were killed with the same caliber bullet. There are additional questions before that, or there are additional questions after that. What caliber bullet? There's one.
Right.
Was it the
There's
same?
a generic same caliber. Was it the same? Did it come from the gun that they found that was in the possession of the Punisher? Like, you know.
Also, we see him using a bunch of different guns in the action scenes.
That's true, yeah.
Right. Well, in fact, isn't that's actually one of the issues, isn't it? It's like they assume it's like a barrage of people and it's one dude. Yeah. Presumably it's because he's using multiple different weapons at the same time. But nevertheless, we ignore that. That's also not how that's definitely not how the Emmy's testimony would have actually ended.
No.
Sorry,
go ahead.
Yeah, you're good. The
Emmy is generally going to be referring to what their report says.
Right.
But that's sort of beside the point.
And they would have gone through every single different
victim,
one and maybe they needed multiple Emmys because there were so many victims, so they might bring a second one or whatever. But okay, but let's assume that the Emmy's testimony ends normally, like it would normally happen. Matt asks what I can only describe as two very generic questions, if anything, that would prop up the fact that he's a, decent medical examiner who's done a lot for a lot of years. And that prompts the ME to say, I need to make a statement on the record.
Yep.
Now, listen, if you are being tampered, that's not how that works. Not that I'm an expert in this, but is that what has to happen? Is like you say to the ME, like, here's what's going to happen. You're going to do a perfectly fine job on direct. The defense is going to ask you two innocuous questions. That's when you just jump up and go, I got to make a statement for the record.
Crisis.
I mean, sure, why not?
Okay.
Yeah.
Sure. Anyway, so that happens, to which the judge's response is to clear the gallery, maybe the jury, unclear. Not sure why.
So can I just, I'm the judge in this courtroom. I'm the justice in this courtroom. And the witness is asked a question and then responds with, I'd like to make a statement. My response is, well, yeah, he just asked you a question, so you should probably say something.
What you're here for, yes.
Now, maybe it's an answer to the question, and maybe it's not, in which case he'll have some sort of objection. But yeah, say what you're going to say. What do you think we're doing here?
The idea that they have to clear the gallery because he might be saying something
Because
unexpected
you
is
have
the entire
no idea what he's going to say.
like the entire reason you have a witness is because you don't know what they're like. If we all agreed what they're going to say, we probably don't need to have them here.
Immediately after, the prosecutor objects to leading on a cross-examination question. My God.
And
Objection, Your Honor. He's doing what he's supposed to do on cross-examination.
They screw up the leading stuff a lot.
It's bad.
And
It's real bad.
I didn't pay attention to what was Matt's actual question.
Oh, how many death certificates have you issued?
That is not a leading question. I didn't think it was, but that's just a standard question.
He said it must have been thousands.
He implies a number.
Oh, okay.
He's like, it must have been tens of thousands or whatever that.
Which, like, it probably is right. It was probably separate. Like, you've been doing this for however many years. You probably issue,
Sure.
We live in New York. You live in New York City. Like,
also, it's cross-examination.
You're allowed to lead the
witness. Right. So
it would be weird if he hadn't issued any. That might be a reason. Like, I was like, oh, actually, that's not my job title. I'm actually more of a secretary. I don't actually deal with the bodies at all. Like, oh, in that case, what are you doing here?
Sure.
Right. In fairness, those 3 questions may have been Matt's only legitimate questions during the entire trial.
That's why he gets the big bucks.
Right.
That's why he gets so many
tamales
given to him by clients. Oh, no, that is Lincoln Lawyer. I'm getting him mixed up.
Tomatillos.
We broke Derrick, Mike.
It's getting late.
It is Lincoln Lawyer where he's paid by a client with tamales, right?
You think I remember anything of that show? You think I remember I've wiped my brain of that entire show.
Where there was a dentist with
definitely not Lincoln Lawyer.
Okay.
I hope it is just because it'd be funny, but I have no memory of the.
That might be a Justified episode I'm thinking of. Never mind.
Pretty close. Same thing.
Well, whatever.
I mean, Foggy gets strawberry pies. Are you sure it isn't this freaking show?
It may have happened in this show. I'm gonna be honest. I like this show, but a lot of it leaves my head as soon as it's gone. Sure.
There's a chance one of their clients gave him tamales. For the hell I know.
I don't know. Yeah.
So as I recall, the ME does his statement where he basically says he falsified the records.
Yep. Yeah, I'll play that now. I played it a long time earlier.
What's all this about?
I know what the defense was going to ask me about, and it's true. I altered the autopsy reports.
You're referring to the official findings on the murders of Frank Castle's family.
Not just them. You don't understand. I had to do it. Those animals came to my office.
Who came to your office?
After the defendant's family was murdered, 2 men I'd never seen before. They warned me if I didn't fix the case reports, they'd come after my family next.
You falsified the autopsy findings on the Castle family.
Them and one more.
Who?
I don't know. Some John Doe, killed the same day, male, adult, multiple gunshot wounds. You can fire me, arrest me, I don't care. I thought this was behind me, but after last night...
Doctor, did something happen last night to impact your testimony?
She was in my house. She tied me up. She said she didn't give a damn who got to me before. If I didn't tell the defense what really happened, she'd hunt me down and kill me.
Who told you this?
I don't know. A woman. Her face was covered, had some foreign accent.
Your Honor, I believe the defense intends to distract the jury and make this case about some impossible-to-prove conspiracy theories.
Impossible to prove. Your ME just confirmed that he doctored the autopsy reports.
He also said that he'd been threatened. If my office finds out that your firm had anything to do with this...
Our firm? For all we know, it was you who sent those goons.
I've heard enough. It's clear to me that whatever Dr. Tepper may know about these autopsy reports has been tainted by threats made by person or persons unknown.
Then the defense asked for a mistrial.
Not on your life, Mr. Nelson. I'm still not convinced these documents, whatever they may be, are even relevant to this trial. I'm striking the doctor's entire testimony and instructing the jurors to disregard anything they may have heard.
Your Honor, I strongly urge you to
Trial will reconvene tomorrow with the prosecution's next witness.
Every every criminal trial he's testified in is now questionable.
Yeah.
And yeah, they should fire and arrest him.
Yeah. And striking his testimony is the right thing to do.
Yeah, I think
he's been threatened. Yeah. This is like the one time that the judge does the right thing.
Now, I don't know, in terms of a mistrial, I suppose she's right that the jury has not heard this. Luckily.
Somehow.
For plot reasons.
Because the deputy got him out even though he wasn't asked to.
Tell him to. Just fortuitous, I guess. This show.
Yeah.
So I guess it's correct the jury hasn't heard it.
Yep.
But the jury did hear testimony that was falsified.
You're right. That is true, because
it's theoretically during the so he never actually testified anything false, right?
Was he?
To our knowledge,
he was testifying about the recent victims, not
people
Frank's
that. Right.
Yeah, but even that, all of his testimony is tainted.
I mean, yes,
right.
Because of this, defense never had the chance to cross-examine him in front of the jury.
Oh, so she strikes the whole thing, right? So she says everything he did is struck.
So then you end up with this problem where, like, the jury did.
The jury heard his testimony. The jury heard, "I have something to say," and the judge, and they are removed from the room, and then they come back in and say, and the judge says his testimony is to be disregarded.
Yeah, this is an appealable issue. This is if he hadn't pled guilty at the end, this would be a great reason to appeal and get the trial thrown out.
Well, it goes to the whole you can't unring the bell, right?
Yeah.
Like now,
you can't unring the bell, and you also can't cross-examine him.
Right. So there are times, and again, I don't know, I haven't done this much research into New York law, but there are times where you can, as a judge, tell the jury to disregard. Usually it's like a question or two.
Yeah.
It's like inadvertent question where they bring up something that's irrelevant or was, part of a motion in limine or, something that's just not responsive.
It happens all the time. It is also always the risk of being an appealable issue.
Right. And I believe it becomes an appealable issue if a jury cannot reasonably disregard it and it severely prejudices one side, which it clearly does here, because basically, I mean, like,
they have no chance to cross-examine him on anything.
They can't cross-examine him. Now, what is interesting is that the ME is cause of death.
Right.
We don't see them bring anyone else on that demonstrates that part of it. So, if you had lawyers who had been practicing law for more than 16 seconds, you would have just changed your case to be they can't prove.
Yeah, that is probably, I don't know, half of their evidence.
They're still alive. That guy never declared them dead. They're fine. They just have some holes in them.
I mean, honestly, because we don't hear much, we don't actually know what the DA is saying about the case, right? And the fact that they did their entire case in 2 days indicates that, like, their case was ME is able to tie bullets from his gun to bullets in bodies. And yet, if they don't have the ME's testimony, who the fuck do they have?
Right. And for what it's worth, an ME is not testifying to the same thing that a ballistics expert is going to testify to. They generally are not going to say, this bullet came from this gun, because they aren't qualified to do that. They could say they found the bullet in the body. Right. But
yeah, actually, that's a good point. Like, the ME would be testifying to the fact that the cause of death of all of them was gunshots to whatever.
And which bullets he pulled out of which bodies, and,
Right. And then they would have the ballistics expert tie that to the actual gun theoretically found on the Punisher or in his wherever, whatever they did.
I want to pause for a minute here and say we have our justice system is one that is open by default. If a judge is going to close a courtroom, which is what she does here, they need adequate justification for that. Usually it's like you're going to be talking about, I don't know, trade secrets,
national secrets,
people's, financial records and things like that are by law confidential. None of that happens here.
No.
None of this is anything that the room needed to be cleared for or could justifiably be cleared for. And I just think that's worth pointing out. You can pretty much go, as long as there's room in the courtroom, you can go watch basically any trial or proceeding, that you want.
Right. Well, and I was going to say, it's one of the few things that the real and movie version of the trial of the Chicago 7 got right, was doing the voir dire effectively of, what was it, like the mayor, to see if the mayor had any relevant information outside of the presence of the jury before they did testimony in front of the jury.
The former attorney general.
Whatever. There you go. That was it. The attorney general. Yeah. And so that's also one reason to close the courtroom is, if you're getting potentially, confidential information or sensitive information that may not go to the jury. But again, and honestly, funny fact, it gets brought up in Lincoln Lawyer all the time. Like, why are we trying to close anything? Why are we trying to close the proceedings? That was the whole thing with, like, in whatever season it was, where we've done season 1 and very early season 2, but there's, I think, something in season 1 where they try to close the courtroom and the judge is like, nope, air it out. What happens?
Oh yeah, when it's like the police officer. Wait, hang on. If I have put someone in jail who on the basis of false evidence, we're dealing with this right now.
Right, and can you clean that up? To his to the transcription,
clean up that transcript a little bit.
To the court reporter. Yeah. He's like, could you clean that up, please? Yeah. So like, there's times where you're just like, no, like, let's air this out. If something's gone wrong, let's do it right. Yeah. And we've talked about this before. There are times where something may be only given to the judge, called an in-camera proceeding or an in-camera, document review, where a judge gets to decide whether there's been privilege violated or whatever else. But as a general matter, when it comes to cases, they're open unless there's a compelling interest otherwise. So, yeah. Just because the guy was about to blurt out something does not mean you clear the courtroom.
That is generally what witnesses do.
Yeah, they tend to blurt shit out. Yes.
So the way the trial ends for the listener, after amazing lawyering by Matt Murdock, who is there at least part-time, and Foggy Nelson, who's doing his best. They're right there. They're about to win the case.
He's doing well enough to become a named partner.
I was about to say that. Soon to be named partner, Foggy Nelson.
Yeah. And then their witness, their client does backflips into just going straight to jail. And he pretty much ends the case by, did he plead? He pled guilty, or he just said he did it all?
Essentially, yeah. He's like, I'd do it again.
Yeah.
I don't need your help. He
really could have saved us a full episode if he just pled guilty during the plea.
If this actually happened in a criminal trial, where the defendant is on the stand and just starts, the trial still has to wrap up. It's not as though they just like, bang, we're done.
You're right. The trial still has to go on. I think at that point you could plead that the prosecution would plead something saying that regardless of what the jury finds, they're guilty because they just pled guilty. Is that complete nonsense?
Directed verdict.
There we go. That's what I'm thinking. It's late, guys.
I would imagine either the judge says, do you want to change your plea to guilty? Or if they say no, then probably the prosecution moves for a directed verdict. But it's not like it's over that day, because then there's still the sentencing.
Well, that's the big thing that was hanging over this whole time. Is there's no way. In addition to, there's no way that any of this trial goes as quickly as these trials are usually a 2-part thing. Yeah. Where if you're in a capital case, you plead to. There's the initial trial for are you guilty of these acts and which ones are you guilty of, and then there's the sentencing, which is based on the sentencing guidelines and like
right. And usually a sentencing report is compiled, even in any criminal case,
especially a case where you're being charged with 30 plus murders and however many other offenses. Now maybe it's easy where it's just like you're getting so many life sentences it doesn't matter.
I think
but
they
there
probably
could be
still have to go through the math.
Yeah, no, there's still the math of like you're getting 1,000 years.
Yeah, I mean, so I think there's 3 different things that could happen. One is Castle's testimony ends, the judge clears the courtroom, and then basically calls counsel into her chambers, looks at defense counsel, and goes, so...
Yeah, I think immediately Matt or Foggy has to at least ask for a mistrial.
Yeah.
Right. Oh, you have to do that.
Now the judge isn't going to grant it.
Yes.
Your own client just kind of went off the rails. That
right.
And I guess we could get into the interesting part if you're like, all right, so a lot of things went wrong here. If they had done a certain number of them correctly, could they still argue for a mistrial? If they had argued, so there's the Emmy who apparently is compromised and shouldn't have been allowed to testify.
Mm-hmm.
So could that be enough to get a mistrial on an appeal? Reyes probably should not have been allowed to be the prosecution because they're a fact witness who was hiding evidence.
Mm-hmm.
That actually might be enough on its own.
But I guess all these they have had to object appropriately and reserved it for appeal.
They didn't do it at all.
They did do it to the ME, right?
Yeah.
So there was the back and forth on the record of so that, Your Honor, how can you let this happen? Blah blah blah. So that's at least on the record.
Yeah. I don't know, and that's probably not enough to overturn the fact that your witness pled guilty.
I mean, declared his guilt to the jury.
Yeah.
Declared his guilt. So Foggy's got to ask for a mistrial, which the judge won't grant. The judge actually probably loses her brain and just immediately says, get into chambers with me. And then counsel go back into chambers and the judge goes, what the fuck just absolutely happened? And looks at defense counsel to be like, you tell me what the hell your guy just did and why I just wasted what in real life would be 5 weeks of my goddamn time to just do this. And then at that point, defense counsel either pulls a rabbit out of their hat to be like, yeah, we knew this all along. We were just going for insanity, even though they weren't, because they weren't able to demonstrate any of that.
You also can't just plead insanity without your client's consent.
No.
Well, it's also unclear what they were doing here, because at no time did they ever say he didn't do it.
Yeah.
Kind of. So I'm not really sure what again, we're still a little unclear what their argument is.
Yeah.
So that's option one is the judge calls them back into her chambers and tries to get them to figure it out. Option two, assuming defense counsel doesn't just go, he's gonna plead guilty now, and now we go to sentencing. Assuming that doesn't happen, I'm sure the judge then looks at the prosecution and goes, I assume you're going to ask for a directed verdict. And then possibly do briefing on it, possibly do whatever. And then the judge will probably grant that. The last option, which is the one that the judge would do as the least risk adverse, is to let it go to the jury. Let the jury theoretically go guilty. And if for some strange reason the jury doesn't, she could always do a judgment notwithstanding the verdict, known as a J&OV, and then say, nope, you screwed up, jury. He admitted it. Yeah. He's going to jail. So let's jump into grades. Mike, take it away.
I like the show overall. There are parts of it that, it should have been 2 episodes shorter. They should have cut some bits. But overall, I like the show. I think that for what you're getting for a random weekly show, really cool action scenes, pretty good acting, good sets. So I like the show overall. It couldn't possibly get a lower grade on The Law. I think it's about as bad as, maybe not the worst things we've watched, but maybe just barely a hair is better than them. So it's the biggest thumbs down I can give it on the law.
Geoff?
Yeah, I mean, on the law, for all the reasons we've been discussing, no. Just no. And for entertainment value, I'm kind of on the fence for this season. I love Daredevil season 1. I think I may not have seen season 3 because I don't remember any of this. And I know Mike, clearly I have, but none of it stuck. So maybe I did watch season. I don't know. Anyway, at least for season 2, I don't like Matt throughout the season. I feel like John Barenthal does an excellent job. I could do without the Elektra stuff and all of the hands.
It really is.
It's
such a weak part of the whole.
Yeah.
thing.
Is it magic? Is it not? What is this black sky thing that they keep talking about that never amounts to anything?
Yep.
And, the comically large hole in the middle of New York. It's just, I don't know. I think I have to be a no on both. I was not a fan of this season.
Okay.
No and no.
Fair. Yeah.
I'm the law for obvious reasons. Like, there are parts that are interesting. Some of the fight scenes are really cool. I could take out of, there are 13 episodes. I could make 4 legitimate episodes that I'd be entertained by.
I think if you cut the hand stuff by 90%, by let's say 50%, you cut 50% of the hand stuff, it would be a better show and much tighter.
Mm-hmm. Yeah.
The hand stuff does it's, and I don't even mind the actress that plays Elektra is good. There's a couple okay scenes in there, but it just doesn't do much for me.
Well, and I'll be honest, I got to the end of having been annoyed watching the entire season, having to look up who these goddamn characters are. We get to the end of it where he, Murdoch admits to Karen that he's Daredevil, and I was like, oh, finally, we're getting the shit I care about and understand. And just so you guys are aware, not to get too far ahead of ourselves, I switched to season 3, and the first thing that has happened is that a building has fallen on Murdoch, and he's severely injured. And I'm like, why did we time jump? We were just getting to a cool thing. So I watched the first 5 minutes, and I'm just now I'm fucking mad again.
What's funny is I have the same experience. I was like, wait,
yeah,
are we gonna go back? What?
Right. And by the way, I haven't finished watching the first episode of season 3 because I got annoyed because I was hoping that there to be some linear thing where we get to see Karen's reaction.
You had my experience
fuck
with
that shit.
episode 1 of season 2 of The Lincoln Lawyer.
Right. Oh, where you're just mad? I gotta get you guys to do more of The Lincoln Lawyer. Anyway, yeah, 2 big no's. And this is a case that the Supreme Court shouldn't even take.
Oh, the law was terrible. Yeah, the law was not close. Yeah.
This is the one where it happens occasionally where the Supreme Court takes it and goes, we shouldn't have taken this. Go back.
Improvidently granted.
Sir, Right. Moving on. Next. Try again.
Stay tuned for next week when we watch Daredevil season 3.
No.
And 4.
God help me. Play credits.
All right.
It's so
It's so dumb.
So dumb, it's brilliant.
No! It's just dumb.
If we do make it to Born Again, we do have the bright side of it's shorter seasons.
Well, that's good.
Yeah. Apparently this season was very, very good. Season 2 of Born Again, and season 1 was not as good.
Season 1, I watched the first episode and was so unimpressed by the action scenes that I just kind of didn't want to watch it.
Apparently they had a whole crew that they hired to direct it. They hated it. So they fired them and brought the original people back on after shooting the entire season.
Oh, jeez.
So they reshot a couple scenes, but I think it's only 6 episodes or something. All right.
The Not So Grand Jury is sponsored by Morwa PLLC.
The opinions expressed in the Not So Grand Jury are those of the hosts themselves and not of their respective employers.
The theme music for the Not So Grand Jury is from Gustav Holst's Jupiter and is in the public domain.
If you'd like to get in touch with us, if you want to suggest future movies, or even if you want to offer corrections, you can email us at notsograndjury@gmail.com or message us on any of our social media accounts.
The Not So Grand Jury is copyright 2026, all rights reserved.